Hey, welcome back, everybody. A reminder to those who are joining the forum by Zoom that we're live streaming the event on Melbourne Law School's YouTube channel, and we're recording it and it will be posted on the university's website soon after it concludes. So it's over to session 3, which is use of digital technologies in the COVID-19 response. And I'll hand over to Ben Lilly from Wipro, who'll be moderating this session. Over to you, Ben.
Thank you, Jonathan, and good morning, afternoon, and evening, everyone. So I'll be your moderator for session 3, which will focus on the use of digital technologies in the COVID-19 response. So this has obviously been an area of rapid discussion in the COVID-19 pandemic. Excited to be joined today by a panel of experts with a really wide range of experiences and data points to help us explore the topic and identify lessons for the future. So we'll be joined by Associate Professor Mark Taylor from the Melbourne Law School at the University of Melbourne and Director of the Research Group EHEALTH, which focuses on the legal and regulatory frameworks governing new technologies, and by Dr. Pura Angela Wico, who is the Philippines Country Manager for ThinkWell, which aims to translate global commitments into creative, practical, and bold solutions for achieving UHC, by Tenzi Yao, Legal Director at the Singapore Ministry of Health, who was involved in the implementation of laws to facilitate digital contact tracing and technological approaches to surveillance efforts during the pandemic. Dr. Vieng Savang Kittipong, Chief of the Surveillance Division in the Ministry of Health of the Lao People's Democratic Republic, who was deeply involved in surveillance efforts during the pandemic. And finally, Kyle Young, who was a consultant with our health board ethics team, and with whom we have worked closely to develop guidance on digital health issues during the pandemic, including the use of digital contact tracing and quarantine tools. So just very, very briefly, I just want to take you through a little bit of the background context here. So, potential for advancements in digital technology to improve health are apparent, and they're already being realized in several areas. In its resolution on digital health, the World Health Assembly recognized the potential of digital technologies to advance the SDGs, and in particular to support health systems. But at the same time, it acknowledged the significant legal dimensions, particularly with respect to data use. And the World Health Assembly urged member states to develop appropriate legal and policy frameworks. Realizing the potential of innovation in digital technology for health is also a key feature of the WHO Regional Office for Asia Pacific's for the future strategic vision of the healthiest and safest region. So the COVID-19 pandemic has seen a rapid proliferation and expansion of digital health technologies. I'm sure you're all well aware. And some of those have been novel, some emerging, and the specific conditions of the COVID-19 pandemic, including the demands it placed on health systems, stimulated interest in experimentation among governments and created a new market for tech companies. It's fair to say that during the pandemic, we've observed both the potential as well as the limitations and risks of digital health technologies. Some of the technological and I suppose public health themes that we observed that were relevant include that personal information has been central to surveillance and response efforts. The technological advancements such as big data have allowed a rapid increase in the capacity to extract and to analyze data, changing the risks associated for individuals and communities. There's been a need to share information quickly across multiple actors in the health system and beyond, as well as across jurisdictions as well, something which was covered by a number of the speakers during the last session. And the private sector has played a significant role as technology providers, as service providers and as users. And it's also seen a highlighting of the digital divide that we know exists in our region. I mean, in terms of the things that we observed that were more related to the role of law in this space, I think we've seen reinforced that law can function as a barrier or an enabler to innovation and the appropriate use of digital technologies. The legal dimensions of digital technology are numerous and multifaceted. There are several laws and legal domains involved, including privacy, service regulation, medical device regulation, intellectual property, and the list goes on. And it's also worth saying as well that legal frameworks and approaches differ markedly across our region due to a range of factors, including culture needs and a universally correct approach. We have seen, though, in our region, I think it's fair to say in most member states, the law did catch up to some extent due to a combination of frameworks in some countries, as well as some of the technologies being novel or emerging, and was yet to contemplate them. And finally, one thing that we observed was the importance of both the digital technologies as well as the response efforts generally. Many technologies, particularly those that rely on user acceptance and uptake, exhibit the network effect phenomenon, affects effectiveness.
I think Mark Taylor Mark, you were first on as the first expert panelist. I might invite you in now, Mark.
Okay, thanks, Jonathan. I'm sure we'll hear back from Ben when the connection reestablishes. Good morning, good afternoon, and good evening from me. And thank you all for inviting me to be part of this important and interesting event. I'd like to start by acknowledging that I live and work, and I'm speaking to you now from the land of the Wurundjeri people of the Kulin Nation, and I pay my respects to their elders past, present, and their emerging leaders. So this panel, as Ben just said, this panel is concerned with how legal frameworks can support the use of digital tech in a pandemic response and how it has done in relation to COVID-19 in particular. I'm going to focus in my short remarks, I'm going to focus on the use of that digital tech in the hands of citizens and consumers, specifically thinking about the kinds of apps which people have been encouraged and in some circumstances required to download onto their mobile phones, and the apps which have been used to monitor location, exposure to contacts, cases, register vaccination status, etc. That kind of digital tech is the object of my concern right now. So how can a legal framework support the use of such apps and enable, noting as Ben just said there, legal frameworks can both act as barriers and as enablers. How can the law here act as an enabler and enable data to flow to support the kind of public health response we're looking for? Well, particularly when we're dealing with the kind of digital tech that I'm concerned with, the tech which consumers are relied upon to use, to download and make use of on their own personal devices, I think that the answer to that question, how can a legal framework best support use, is by best supporting the conditions of trust and accessibility. Now, trust and accessibility are both important. Ben noted in his introductory remark just before we lost him that there's a direct relationship between trust and effectiveness in this context. The use of digital tech in the hands of citizens is going to be more effective. The data you're going to get is going to be of a higher quality if people are able and willing users, if they're motivated by a sense of collective benefit, a sense of solidarity. Accessibility kind of speaks for itself. You have to be able to take account of varying levels of digital literacy. The apps have to be available to people. They must be able to download them and they must be able to use them. And that means in part that they must be present information in a language which is accessible, both an appropriate accessible in all manner of ways, not least of all with regards to the language which is being used. So as well as accessibility, we are concerned here with how legal frameworks can support trust. And I'm going to draw that distinction that Honora O'Neill makes very clear in her work between trust and trustworthiness, and suggests that what the legal framework should be trying to do here is promote trustworthiness rather than trust per se. So what does trustworthiness look like in this context? Well, the literature on trust and trustworthiness tends to call out three different features that are associated with entities and organizations and operations that are perceived to be trustworthy. They relate to competence, to integrity, and to benevolence. So if we want the digital tech to be trustworthy, it has to be perceived to be competent. Now, that's not just about it actually functioning as it should. I mean, there is a technical answer to this. Does it actually work? There's also a social answer, which is a social aspect to this, which is about whether or not people perceive there to be a risk that the digital tech can actually guard them against. This is about whether or not it's technically functioning, but also whether or not people think it will work to protect them and those that they care about from a health risk, which is in part about the perception of that risk, as well as it is about the extent to which the app or the device itself is going to work to protect them from that risk. So there's a technical aspect to competence, there's a social aspect to it, but there's also a legal aspect. And there was some concern in relation to at least one iteration of the contact tracing apps that was used in the UK, that the governance arrangements that set up around the app might actually have affected its effectiveness by denying to NHS contact tracers the telephone number of those that they might otherwise have been able to reach out to and follow up with for contact tracing purposes. It was intended to prevent access as a privacy protecting measure, but it actually arguably interfered with the effectiveness because people couldn't be followed up by contact tracers. And when people were given the opportunity of voluntarily providing a phone number for that follow-up call, in Ireland, 80% of people who were given that opportunity actually took it up. So we have to ensure not only that these systems work technically, that there is the social aspect of it is taken into account, but also that the governance supports the flows of data which will support that the demonstration of effectiveness. So they have to be competent. Competence is an important part of trustworthiness. But the other part of trustworthiness here is what I think is going to be particularly important for the law to actually support and to be able to deliver on. And that relates to integrity and benevolence. So do people perceive the digital tech to actually work for them and for those that they care about? Do they get something out of it? Does the app and the use of the data reflect their values? Does it protect their interests? Now, we know that the use of these apps doesn't take place in a vacuum. We know that there's a lot of concern in relation to data more generally these days, concerns often associated with mission creep and secondary uses of data being used for purposes beyond the original purpose for which it was disclosed. And there are in this context a series of considerations in relation to the digital tech which relate to that question of mission creep and concerns in relation to secondary use. So the first thing I'll just call out relates to the location of the data. Where is it being kept? Is it only on the device which is in the hands of the consumer? So is it being held in a way that actually physically prevents any secondary use? Or is it being shared with a third party, a private company, a government? If it's being shared, if the possibility for secondary use exists, then what are those permitted secondary uses? What are allowed and what's being prescribed? And it's important here to recognize that a perceived misuse may well go beyond questions of law. People often perceive a misuse of data to be a use of data for purposes other than that for which it was provided, regardless of whether or not it's lawful or not. So the question of whether or not people are going to accept a use is not necessarily answered by questions of whether or not a use is lawful. So what are the permitted uses? Are there any permitted uses beyond that primary and principal use of contact tracing pandemic response? What are the rules that proscribe any additional uses, and how effectively can those rules be enforced? So there was, in relation to Australia's COVID Safe app data, an initial concern, at least discussed through the media, about the data being held by Amazon Web Servers, AWS, and the question as to whether or not US law would permit US intelligence agencies to access that data because of the relationship between Amazon and the United States of America. So could even Australian law effectively control uses of data in that context? That was one of the questions that was being asked. So what are the legal controls that will proscribe uses beyond the primary use, will prescribe any secondary uses, and how effectively can those laws actually be prosecuted? In relation to that effectiveness of enforcement, another issue that arose in Australia is when we tended to move from the use of the COVID Safe app, which the use of it tended to fall away, principally because of those issues of competence and whether or not it was actually seen to work and be effective. There was a move towards the use of digital tech to support QR codes and location tracing, contact tracing in that way. And employers and companies and organizations were required to maintain some details, are still required to maintain details of people who frequent their establishments, collect names, contact numbers, those kinds of things. Well, initially that was done through the companies themselves collecting that information, first of all paper-based and then digital, using these QR codes, but the QR code systems were being provided by private companies. They were collecting the data through web surveys, web survey tools. And although they weren't supposed to collect any more than first name, telephone number, location, date and time of entry, although they weren't supposed to use this information for anything other than the public health response, in fact, routinely, I and many others experienced web surveys prompting for additional information, including requests for permission to use data for marketing purposes. When you roll out this kind of major change across the whole of society, the ability to ramp up enforcement in a way that ensures that the rules can be effectively policed becomes a massive question and challenge. In part because of that, I think we moved away from companies relying upon their own capture and web surveys to a government provided app. In Victoria, we have the Service Victoria app now, which all companies are required to use rather than their own digital platforms. But that comes with additional questions, or at least alternative questions in relation to secondary uses, and there have been issues in relation to secondary uses by the police, and there's been a somewhat uneven response across the states to requests by the police to get access to that location data. Gradually, the states and territories have tended to move towards prohibiting that, or at least significantly restricting it. So, for example, in Victoria now, the legislation proposes that police access would only be permitted if there was an imminent threat to life, health, safety, or welfare, and there was a court order. So, in short, and just to summarise, public confidence can be undermined if the uses are not seen to be uses which are in the individuals and community interests, and governance in this space needs to be able to support trustworthiness and protect against misuse. And it's really important to recognise that misuse is often perceived by public to be any use of data beyond that for which it was originally provided. Thank you.
Thanks for that, Mark. I do hope that everyone can now hear me. We've been having it's a little bit ironic, but we are having some connectivity issues in WHO. So look, thanks for those fantastic comments. I think that you raised, it was really helpful to unpack the difference between trust and trustworthiness and some of the elements involved in that, and particularly the perceived risk concerning mission creep. And I think that we've all come across situations in our personal lives where we've been asked to provide information for the purposes of contact tracing or such like, and then later down the track found that we've received marketing material and so on. And I think that we've seen it play out as well. You mentioned law enforcement agencies seeking access to personal information extracted from our contact tracing efforts. And I think, as you were alluding to, the risk there is that it may undermine the public health effectiveness of those technologies, because people may be less willing to share the information and to be honest with contact traces. And of course, during a pandemic, our principal interest really is in getting accurate information from our cases and our potential contacts, and those sort of secondary or potential secondary uses of the law have a lesser significance during a pandemic scenario. Now we'll be turning to our next panelist, Dr. Angela Wico.
Okay, so again, good morning, good afternoon, and good evening. It's a pleasure to participate in this forum. I'm Dr. Angela Co, Country Manager of Think Well in the Philippines, and today I'm tasked to share insights and lessons we've garnered on the legal and regulatory environment for digital health as we were providing support to the Philippine DOH for the COVID-19 telemedicine sandbox. So as a short background in terms of the country, there has been a growing number of small-scale implementation of digital health solutions in the public and private sector over the last decade. So these have provided insights into how digital health can be used to improve health outcomes in a low middle income country. However, uncertain government policies have constrained its development. So over the years, the country has developed an e-health strategy, a data privacy law, and started to ensure linkages with the National Health Insurance Agency. But these developments have been slow and a lot of gaps remain. So in terms of demand side, internet literacy had been improving in the country, although much needed to be addressed in terms of connectivity. Overall, the lack of effective political prioritization, as manifested by inadequate ICT infrastructure and poor use of policy levers, have led to the slow adoption of digital health solutions. So the COVID-19 pandemic further emphasized the need for effective digital health solutions. Fear of catching the virus and the government-instituted lockdowns made access to healthcare increasingly difficult. Healthcare providers needed solutions to access information and provide healthcare remotely. So the government, mainly through the DOH, responded to these challenges through multiple mechanisms. So it centrally developed digital solutions, including offering a hotline for COVID-19 concerns, developing a chatbot to help in disseminating information, as well as developing websites and apps for submission of COVID-related data. It also offered guidance for LGUs, providers, and other stakeholders in areas such as the conduct of telemedicine and in data privacy. But to fully scale the use of digital health solutions, though, the government also needed to engage with external stakeholders, including the private sector. They were able to do this through the adoption of the contact tracing Stay Safe app and through the establishment of the telemedicine sandbox. So again, we were able to take part in the sandbox as its process documenters. So the telemedicine sandbox was jointly administered by the DOH and the National Privacy Commission by enabling a no-cost partnership arrangement with telemedicine providers to offer a free consultation during the pandemic. So and the engagement was treated like a regulatory sandbox where the DOH was able to closely monitor and learn from the implementation to strengthen its regulation. So for telemedicine providers to be engaged, they had to secure certification from NPC and DOH that they are compliant with current privacy and quality standards. So engaged telemedicine partners were advertised to the public through official channels, and in return, the providers were required to submit their utilization data to DOH for the duration of the engagement. So in total, around 5 providers joined this initiative during the pandemic. So its implementation so far illustrates the potential strengths and limitations of how digital health solutions can expand the accessibility of health service delivery. Through the sandbox, the government was able to provide a significant amount of consultation to those affected by the pandemic. These were mostly provided through telephony, since this is the medium that's most accessible to the general population, even if there are limitations in the information that's being garnered from it. For the DOH, the sandbox was a driver for them to create regulatory processes and mechanisms, such as the certification process for the different telemedicine providers. From this process, safety and privacy gaps of these providers have been assessed and addressed. So there were a number of legal and regulatory concerns that have arisen as well because of the scale offered by these digital health solutions. So for example, data protection and legal concerns from offshore data storage was also a repeated concern, as what the previous speaker was also mentioning, especially with most data being stored on the cloud. So enforcement capacity of the government is also an issue, with some providers complaining of slow turnaround time and lack of follow-through of the government in terms of next steps. Sufficient incentives is also a concern, as shown by the waning interest of providers to join this initiative. Beyond the sandbox, there's also a question in terms of the quality of the unregulated digital health services that's being accessed by the general population. Ultimately, the inadequate capacity of the government to regulate digital health solutions will serve as a constant barrier to equitable access to digital health solutions if appropriate reforms are not made. So a summary, the country was able to demonstrate the value of digital health during times of emergency and even beyond. Because of the pandemic, there's been an increased movement in terms of legitimizing the technology and the industry. However, significant gaps remain, and this exercise has also generated useful insights into the continuing and often unforeseen risk of digital health. So to further improve access to digital health service, the government, with DOH's lead, needs to further enable a conducive multi-agency regulatory environment, leading to responsive policy making. So this in turn will lead to appropriate incentives and disincentives towards quality and equitable access to digital health service. So lastly, the government still needs to continue and getting further insights into the broader health policy environment of digital health. So there's a need to further generate knowledge on this subject that would lead to the development of more responsive policies that better fit the context unique to each country and the technology being regulated. So thank you.
Thank you, Dr. Wiko, for that very efficient presentation where you covered a great deal of content in a very short space of time. I think it's a fascinating approach that was taken in the Philippines. Of course, regulatory sandboxing is not a new approach. It's seen quite often in other regulatory environments, particularly financial regulation. I don't know if it's been widely applied in our region in the health space, but I think it's interesting to reflect upon the work that occurred in the Philippines and some of the outcomes that were achieved, and yeah, what sort of challenges that you face were, and potentially what some of the benefits in that approach were as well. And certainly, as someone who's been in the Philippines, I've noticed as well a proliferation of telemedicine service providers recently. And so it's interesting to consider how those services might be regulated, and as you mentioned, how the government might use legal and regulatory frameworks to ensure appropriate quality and to ensure cost effectiveness as well. So maybe we might move on to the next panelist. Next up, we've got Tensi Yao from the Singapore Ministry of Health. So over to you, Tensi.
Good morning, good afternoon, good evening, everyone. If the slides can't be put up, I'll just base my presentation on the framework that Mark had earlier spoken on, the one about trustworthiness being important and competence, integrity, and benevolence. So I work in the government of Singapore at the Ministry of Health. So the perspective I'll be sharing today will be the government's perspective. And I think Like most countries, we had implemented digital contact tracing solutions and digital quarantine monitoring and things like that. The title of my presentation was actually Big Brother is legally watching you. So our contact tracing solution is called Trace Together. I don't think it's very different from the one they have in Australia. It uses Bluetooth signals to just see who you've been in close contact with. And subsequently, if you're determined to be a COVID positive case, the government will be able to retrieve that data to do contact tracing to ensure that your loved ones are protected and to ensure that there are no clusters that will break out. I was going to actually break this down using the framework that Professor Mark Taylor spoke about earlier. So I think there is no question that the citizens of Singapore are aware that these technological solutions are viable. So the competence issue is quite settled. These do work, or at least they do work when the numbers of infected in the community are not overwhelming. I think prior to the Delta variant, this Trace Together solution was very effective for Singapore in containing the spread of the infection and to make sure that our numbers were low. So the issue I would say for our government, for Singapore's government, was the one about integrity. And I think Mark said many things that resonated with me, or rather, should I say, he said many things that I wanted to say. So now that he said them, I suppose I can give a practical application of the principles that he spoke about. So the issue of mission creep was actually a very real one, and it did come up in our country. So initially, these technological solutions, these trace together applications and tokens, they were adopted by our citizens voluntarily. I think Mark mentioned that 80% of the people in Ireland just were willing to do it. And it was similar in Singapore. There was quite a high demand for these application devices. But one thing that I would say may have been overlooked was that we didn't think about proper reassurance to members of the public about how the data would be used. So the primary purpose, right, is for contact tracing, is for public health purposes, is to prevent the spread of infection. But there are statutes in Singapore that, pre-existed these devices. And for example, there's the Criminal Procedure Code, which allows the police, right, the state, to require information related to the offense, the commission of an offense, to be handed over to the authorities. And one angle was that the information in the device and in the application stored locally, by the way. It is stored locally until it is you are found to be COVID positive, in which case the data is transferred to the government servers, not AWS. But because of the provision in the Criminal Procedure Code, people were worried that the government will be using this contact tracing data to investigate other kinds of offenses, right? So that would in turn impinge on the take-up rate for these devices and applications. So because this was such a pressing concern, actually an apology was made in Parliament, and an amendment to the relevant legislation was made to make it very clear that all this data, the trace together data, would only be usable for the purposes of contact tracing or for the purposes of maintaining the contact tracing system's integrity. So it was quite big news in Singapore because politicians seldom apologize. But after this, I think people were more reassured and they could go about with their daily lives with these devices safe in the knowledge that there would be a law protecting them. I think Mark also mentioned that, we need to know how enforceable these rules that prescribe the use of the data are. So Singapore being a very small country, we are a city-state, and I think we are probably smaller than most Australian cities physically. It is easy to enforce. The problem is, this is one of those laws where you would be enforcing it against because the only people who have access to the data are people who work in the government. We do not use third parties because I think Mark mentioned earlier that there's a much higher risk, or rather much higher perceived risk of abuse. So the government gets all the data, and if there is any prosecution to be taken out, it would be against a government employee. Thankfully, to date, there has been no such case. I think the benevolence, for want of a better word, is there. Everyone knows that these solutions are only intended for contact tracing. But I have to say that maybe this is, and I'm speaking, personally here. I'm not representing the views of my employer. There is a tendency in Singapore towards law and order. So while amendments were made to make clear to the public that this data would not be used, for investigating most offences, there was a certain list of offences that was carved out, and for these offences, which are like terrorism and kidnapping, the trace together data would be usable for investigations. So I think this was a bit of a halfway house, and we all know that a good compromise leaves nobody happy. But it was decided upon, and that was the position taken. I think on the ground, much of the population greeted the news with a slight sense of derision, because if you are going to be a terrorist, carrying out a terrorist attack, you are hardly going to be carrying one of these devices around you. But I digress. Before I move on to the next slide, I just wanted to point out something interesting about this trace together solution, which is that initially we had thought that most people, because they already have smartphones, right? They have their iPhones, they have their Androids, they would just download the app and just use the device, the app on the device for the purposes of contact tracing. But as it turned out, there was actually a massive demand for the tokens. We did some analysis, and we came to realize that people actually preferred the tokens because they perceived it to be safer. It was a physically separate device from the phone, and it just seemed harmless and innocuous. So even though from the engineers, both are identical in terms of potential invasion of privacy, many people much prefer the physical token, and maybe this is something we can, or at least this is something that the government will take into account when we are designing future solutions. This was another technology that we still use to this day. Trace Together was meant to map person-to-person transient or non-transient interactions, whereas safe entry is something that you do whenever you go to a shopping mall, a restaurant, or a shop. You just check in, and now it's been integrated together with the Trace Together application and the Trace Together token. So the same issues arise, but and the same privacy safeguards are there. You can't use this data to investigate except only the most serious crimes. The data that is logged is stored locally on your phone and only transmitted to a server once you've been determined to be a COVID positive case. There is no question of any more mission creep because of the legislation, and there's no third parties being used to store the information. Yeah, so since this is largely similar, we can move on to the third slide, which I think is a bit more interesting. So in Singapore, whenever someone is COVID positive, we usually try to isolate that person, or at least, we try to isolate them. We have a variety of measures. You have a quarantine order, an isolation order, and one of these is the stay-home notice. For people who are under a stay-home notice, which is slightly less serious than a quarantine order, the supervision is not as robust, but we do use a technological solution to that. So if you receive an SMS to say respond, then you have 1 hour to do so. I think this solution, I mean, it appears at first glance to be very invasive, but actually, I think there's quite a nice compromise here. You don't have to turn on your location services at all times. You only have to do it when you are pinged, and the information. I mean, if you are given a bit of a chance really to rush home within an hour, and if you are out, you've been out and you can't come back within an hour. Singapore's a very small country, by the way. Then you do deserve to have your privacy invaded because you have broken the law and you are a public health risk. So I thought this illustrates nicely how what a good balance between privacy and expediency is. I think it was Mark earlier who also noted that if you don't have trust in your solution because of the lack of trustworthiness, then it will be very difficult to encourage people to take up the digital solution. And for something like contact tracing, activity mapping, network effects are everything. And if you don't have enough people to constitute a viable network, then the solution is worthless. So compromises like these are actually very valuable and very important to encourage people to be part of the solution to help weed out the infectious disease spread. First, I have to preface that this solution was actually not really used extensively, as you can imagine, it is something that is not going to be very popular. But in a nutshell, it is a tracker, and we found that even with the assurances that it's not equipped with audio or video recording capabilities, it was not something that went down well with the population, or should I say the electorate. But yeah, I think I just put this in to round up all the measures that we do use, the spectrum of measures that we have in Singapore. Yeah, so I've mentioned this earlier. My conclusion was basically my speech, really, that we do need to find a way to strike a good balance between personal privacy and the needs of public health. Actually, as a tangent, we are witnessing this more and more as the cases in Singapore are increasing. People are frustrated, they're growing frustrated with people who don't use these devices. And actually on the vaccination front, people are also frustrated with people who refuse to undergo vaccination. That's an analogy. But the basic question is whether the needs of the many should trump the needs of a few. I think as a jurisdiction, Singapore has never really had particularly strong privacy rights. So it was quite easy to introduce these digital technology solutions. But that is not to say that the status quo will be maintained forever. And speaking, I mean, that is me speaking as a government man, but speaking as an individual, perhaps it is also time for us to think about how to better protect privacy, given how these solutions will become all pervasive, and given how data breaches and security hacks and all things like that will become more and more commonplace. So actually, that is all I have. I must say, I did want to ask Mark a question about the benevolence point. I don't think I caught him unpacking the third limb of the trustworthiness framework. So I've talked about competence and integrity, but if we are going to talk about the benevolence of the Singapore government, I think I would have to leave that at the Q&A. Okay, thanks very much, everyone.
Thanks for that, Tensi. Look, another fantastic presentation, and yeah, let's pencil that in as the first question to our Q&A at the end of the panelists' remarks. So I'll hand that one over to Mark when we enter into the open discussion. But yeah, a fascinating presentation. I think that in a lot of ways, Singapore has been a little bit of a leader in our region in this space, and certainly the trace together technology we know generated quite a bit of interest in our region, and there were some applications that were in other countries that leveraged that particular form of technology. So it's interesting, I think, to reflect upon how its effectiveness in Singapore, and perhaps compare and contrast that with some other jurisdictions as well. And I think that you mentioned that in the title of your slide, it was I think it was Big Brother is watching you legally, and I thought that was sort of quite a cheeky title. And I think the question I would ask is whether we're now moving from an age of Big Brother to an age of Big Brothers, where I think much of the focus has been on the privacy risks associated with the government collecting and using data. But we've also seen during the COVID-19 pandemic the proliferation of private applications, as well as obviously the government's dependency on private platforms as well. to implement its own applications, and then how those risks are perceived by individuals and communities. So thanks again for your rich presentation. We'll now pass to our next panelist, who is Dr. Biangsavan Kitipong from the Lao People's Democratic Republic. And I believe that we have some slides to share. Over to you, Dr. Kitipong.
Good morning, good afternoon, good evening. My name is Dr. Biangsavan Kitipong, Chief of Surveillance Division, DCDC Lao PDR. Sorry, my video have problem. I am very pleased to, on behalf of Lao team, to share with you about recall framework and its role in digital technology in COVID-19 response in Lao PDR. Next slide, please. Regulatory framework for the use of digital technology in health is an area where due attention has not been given so far, and the need to strengthen this key area was highlighted during the preparedness and response to COVID-19. This need was most felt when Lao PDR start developing and using different digital technology. As in most other countries, Lao PDR to embark on using many digital health technology in the response of COVID-19, a system which promotes the use of taking wristband for those arriving from abroad and quarantine was introduced by a private company. A mobile app to track the movement of commercial tax entering the country was developed and rolled out to ensure adherence to national guidelines. Many different information systems were rapidly developed to support the capture and management of data of those tests for COVID-19, confirmed case, hospitalized case, to track capacity data of quarantine center and isolation facility, and to keep count of the number entering the country through the various points of entry. Similarly, systems were also rapidly developed to capture data on those vaccinated for COVID-19 and for the issuance of vaccination cards with verifiable QR codes. Due to the widespread use of the platforms such as WhatsApp, Vital, and confidential data is transferred through such platforms, systems were also implemented for social media listening for enhanced surveillance as well as for improved communication strategy. Although many these mentioned systems were successfully rolled out rapidly, some of them require strengthened regulatory framework for long-term sustainability, complaint and enforcement, and for better preparedness for future health emergency. Area where strengthened regulatory framework would be particularly beneficial in Lao PDR includes for improved complaint for national guidelines and to overcome challenge in enforcement, to be able to engage better with private sector while not compromising on data confidentiality, to facilitate seamless interoperability between systems from different sectors such as immigration data at point of entry without having duplicate efforts, for improved clarity in role and responsibility of other ministries, such as the Ministry of Technology and Communication is supporting the development use digital technology, to ensure purpose limitation or entirely disclosing the use of data for purpose for which is correct and not use it for other purpose. Finally, just to boldly share some of the lessons learned by Lao PDR, The use of digital technology are pivotal in responding not only COVID-19, but it also going to be pivotal for dealing with further health emergency. Therefore, national public health law need to be amended to facilitate the appropriate use of digital health technology while ensuring necessary measures are in place to protect data confidentiality and protect that and protection and that they are not used for deny any serve to the people. It should also be clear on how private sector could be safely engaged to rapidly roll out digital technology for the greater good of the people we serve. ขอบใจหลายๆ Thank you very much for your attention.
Thank you, Dr. Vien Savan, and yeah, thank you for your reflections on some of the practices in Laos, some of the challenges that you face, and your suggestion of what some of the priorities might be for the future. There were a number of points that you made that I found quite interesting, and I think we're starting to see some common themes emerge. I think it's interesting to note that both Singapore and Laos, two quite different jurisdictions, raise the challenge of enforcement. I think it's one thing to have sort of legal and regulatory frameworks on the books. It's another thing to have the capacity to enforce those, or to enforce those standards. Sorry, particularly where you have a new and emerging technology that the government may not yet fully understand. And I think it was also quite interesting you mentioned the need potentially to review your public health law in light of how digital technology has been used for surveillance purposes during COVID-19. I think that was something that was mentioned by Genevieve and some of the panelists in our first session, that many of the public health laws in our region date back to a time where information was collected and shared very differently to how it is now, and didn't contemplate the potential applications of technology in this space. So thanks again for your presentation. We'll move on to the final panelist now, Kyle DeYoung, who's a consultant with the Health Law Networks team here at Wipro. Over to you, Kyle.
Hi, everyone. Thanks, Ben. For my presentation, I'll be speaking a bit about the development of legal frameworks. So as we've heard from a number of presentations thus far, legal frameworks are incredibly important for the development of digital technologies, and specifically digital contact tracing and quarantine tools that have been deployed during the COVID-19 pandemic. The WHO Office for the Western Pacific published a document through the Health Law and Ethics team in June of 2021 titled "The Considerations for Strengthening Legal Frameworks for Digital Contact Tracing and Quarantine Tools for COVID-19." And this document outlines the steps and the important considerations that need to be included when legal frameworks are created to respond to the tools that were rapidly rolled out for contact tracing and quarantine for COVID-19. There's been a lot of discussion so far, so I'm going to maybe jump through some of the earlier bits of my presentation just to get to some of the more important. So as we heard earlier, there are a number of legal and ethical dimensions to the development of the digital contact tracing and quarantine DCTQ tools. As we've discussed, the amount of information that's collected and how it's being collected is incredibly sensitive to a number of people. And the amount of data that's been collected is immense at times. And the sensitivity and the trust that is at play, as Ben and discussed early on, is incredibly important for the actual effectiveness of the tools. If the users don't feel that their data and their information is protected and is being utilized for a valid reason and is secure, then people will not use the apps and the report in particular focuses on Bluetooth and GPS style apps, similar to Trace Together that we've just heard about. Additional legal and ethical dimensions from the considerations for the tools are things like the risk of commercialization within public health infrastructure, meaning if private companies are participating in the development of these DCTQ tools, then there's a risk that data or information can be transferred to private companies, or vice versa, where private companies have access to users' data and can use that for commercial or other types of purposes. As discussed earlier, the application of the DCTQ tools has a direct impact on individuals' autonomy, and it has the potential to exacerbate inequities. If, for instance, having a Trace Together or another type of DCTQ tool on your phone is a requirement for entry, and you don't have access to a phone, or you don't have access to a token, that can place many barriers into individuals' day-to-day lives. There are a number of reasons that legal frameworks are important for the development of DCTQ tools. It's really important to establish a lawful basis for the use of the tools and to govern the use of the tools and their data, and also ultimately to cover the dismantling of the use of the tools and their data at the end of the need or the pandemic or whatever the underlying public health rationale is for their development. Legal frameworks are important to provide safeguards and to ensure the privacy and secure retention and encryption of data. And overall, having strong legal frameworks in place, as mentioned earlier, builds public trust and ultimately encourages and supports the uptake by members of the public. Primary legislation, so statutes, law, is the most effective means to achieve these purposes. And that's because, and I'm sure we're all aware of this, but lots of apps and lots of tools come with terms of use or privacy policies that users, might not understand in its legalese. I'm sure we've all scrolled through websites or privacy policies for apps that we've never read and just scroll to the bottom. So having a strong primary legislation in place for the DCTQ tools is incredibly important to allow individuals to actually understand what they're signing off on. And in the region, overall legal frameworks for both personal use information generally and for e-health data and privacy exist, but they're not universal, and their use is growing. So the lack of those types of legal frameworks in some jurisdictions means that specific legal frameworks for things like DCTQ tools is incredibly important. And just finally, the document, as I mentioned earlier, has a checklist that outlines a number of considerations for the development of legal frameworks for these tools. And these considerations are, kind of run the gamut through a number of different things. There has to be a clear understanding that users are consenting and voluntarily using the tools. The amount of data collected should be minimal, the minimum amount required for the actual goal of the tool. There should be clear outline of how data will be kept secure, how it will be encrypted, and how it will be used. There should be time limits on how long data will be held and what will happen to the data at the end of the period of use of the tool. And there should be clear oversight and governance. So who within government is administering the tool and who is overseeing the tool's use and evaluating its use. And finally, there should be a human rights and equity lens on any work that's done with respect to DCTQ tools, because as mentioned earlier, these tools can place barriers on entry for lots of different sectors within society, and any barriers or any impact on marginalized groups should be at the forefront of any consideration. Thank you.
Thanks for that, Kyle, and apologies for causing, I think, some of the issues there with your slide. And I was very late in the evening where you are. So it's a little bit unfair of us to disrupt your flow there. But thank you. I think that you raised a number of really interesting points actually. And one thing that you mentioned was that we know from the Global EHEALTH survey, I believe conducted in around 2015, that the Western Pacific region has one of the lowest concentrations of general privacy frameworks among all WHO regions. And of course, member states in our region are at very different stages in terms of developing our legal and regulatory environments for digital health. And we certainly shouldn't expect that countries would start from a low base and then develop a robust legal and regulatory environment that encompasses all of the principles and considerations that we're mentioning. But it is certainly important, I think, for member states to consider what their priorities are and potentially what their long-term vision in that space is. I think that there's a number of intermediate steps as well that countries potentially can look to make to build those frameworks over time. So it's something that in our office is something that we're looking to support a number of member states in the region to conduct exercises just like that. So thanks again for that presentation. We're now moving into the open discussion part of the forum. So please get your hands ready. Before we open up to the floor, what I might do is pose Tensi Yao's question to Mark Taylor. And I believe, correct me if I'm wrong, Tensi Yao, but you were keen for Mark just to elaborate on the issue of benevolence and how that factors into trustworthiness and potentially the role of the law in that space as well.
I've put a link into the chat, Bill, because there's a lot of literature on trust and trustworthiness, but one of the pieces I quite like came out in '95 in Academy of Management Review, Mayer, Davis and Shurman, an integrative model of organizational trust. And I've put the link to that article, and they use this framework. They talk about ability rather than competence, but they talk about ability, integrity and benevolence. And when they talk about integrity, they're talking about the trustor's perception that the trustee adheres to a set of principles. Do you adhere to a set of principles that the trustor finds acceptable? So I think this is a kind of a set of values. Do they ascribe to a set of principles, a set of values which accord with those which you yourself hold and which you consider to be acceptable? Benevolence, they describe as the extent to which trustees believe to want to do good to the trustor, not from an egocentric profit motive, but do they actually want to do good for the person that's investing trust in them? And so they're talking about benevolence there, which of course is might be associated as an attitude of a person, a benevolent person. It's a kind of a moral virtue. We might talk about systems, particularly, well, we might talk about systems, information systems, digital technology, not necessarily in terms of benevolence, if we're not talking about the individual's motives behind the use of them, but we're talking about the operation of the systems themselves. We might instead talk about beneficence rather than benevolence. Do they actually work to the good of those who are using them? And so I think there's slightly different questions, or slightly different issues, those of integrity and those of benevolence. And benevolence and beneficence is really about whether or not it's actually going to work to the good of the people who are using these technologies. And if we want people to willingly accept whatever risks they perceive to be associated with uses these technologies, then kind of put it simply, what do they see as in it for them? How does the use of these technologies work in their interests, in their favor? How does it do them and their loved ones good? Does that help at all?
Thanks very much, Mark. I suppose coming from quite an authoritarian country, I'm just wondering what would be a good way for the government to demonstrate benevolence? I mean, assuming that they've had a history of not being benevolent or beneficent. So what would be a quick and easy way to convince people for this particular application, for this particular context, you can trust us. This is good for you. But if this is impossible to answer, it's fine.
First of all, I don't think you say you can trust us, because it's saying to somebody that you know it's okay, you can trust me, isn't necessarily the very best way to demonstrate that you're worthy of that trust. And I think there are I think you mentioned this within your own presentation, which I thought was great. Really clear articulation of how this might work in practice. There is this. There's a need to demonstrate the value proposition. Just what good is this going to do, and why is this good for you? But alongside that, there's a need to demonstrate how the potential misuses are going to be guarded against. And I think often, particularly by people who are well-meaning and perhaps are benevolent or operate with a principle of beneficence, there is this rush to do good. And in the rush to do good, they don't necessarily give adequate attention to the misuses which might be made of data, because that's not their intent. They don't want to do bad or harm. And because they don't want to do it, they don't consider preventing it. They don't necessarily give sufficient attention to it, it's my view, and it's to some extent my experience as well. So I think that what I'd be encouraging those who are benevolent to do is to consider what misuse might be made of the data from the perspective of the individuals who you're asking to trust you, and then to put beyond doubt that there can be no such use, or if there is any such use, you know, you've done all that you reasonably can be expected to prevent it. So in Australia, I'm thinking about something that Carl said, in Australia, in relation to the COVID Safe app, when it's used and the control of the data came through a ministerial determination, one of the concerns was with the way in which the law can be changed through ministerial kind of decision without having to go through a parliamentary process. And it wasn't until that the controls were effected through a different kind of instrument, a primary legislation that required parliamentary consideration, that people felt that it's not just that the rules were right, but they were sufficiently kind of assured into a medium and long term as well. So just some initial thoughts. So
thanks very much. Thanks. Yeah, that's useful. The problem is, what if we are not inherently benevolent? Then, but you know, that's fine. Let's move on.
Thanks for those very thoughtful comments. That was a great discussion that I really enjoyed. And I think you touched on something, both of you, that there are very different values that exist in our region, and public health authorities, to a large extent, are dependent on the general trust in our government, and of course that will have a big influence on trust in the public health response and of the use of digital health technologies generally. And something we haven't really had the opportunity to touch upon in this session yet is exploring how different values with respect to our privacy may necessitate different types of legal frameworks, different types of our legal mechanisms. And people in different parts of our region may be concerned about different forms of misuse, not only in terms of the populations that may be targeted, but in terms of their understanding of the risk, particularly as individuals versus potentially a community-based risk, and how that might play out, and what different legal mechanisms we might be able to to consider to resolve some of those concerns and to ensure that youth digital health technology, as you mentioned, Mark, is benevolent and can engender trust in the population, because ultimately that's what's going to ensure that it's most effective. So with that, I'll call this session to a close, and I'll hand back to Jonathan Liebman to wrap up for the day. Thanks very much.
Thanks very much, Ben. Thanks to all the panelists for another great session. So we'll draw first day to a close. I'll just make some really brief remarks. So we covered two quite different areas, public health and health emergency laws in the first session, and then digital technologies in the second. I think there was some interesting common themes. I think we saw in both the importance of legal frameworks. We also saw the complexity of the intersection of different legal frameworks. So in the first session, public health, state of emergency, disaster. In the second, public health, privacy, consumer protection, health services, and across those, the importance of having clarity of roles and responsibility, and the importance of trust and trustworthiness. I think we saw in both that COVID-19 has presented challenges to the frameworks that we might not have anticipated before a pandemic of this nature. We've all been learning really important lessons in real time, and doing our best to adapt, to review, revise, improve laws. And I think we saw that countries are really dealing with really common challenges, but also some different challenges, and taking different approaches that are appropriate for local circumstances. So I just very briefly will just remind you what's ahead for tomorrow. We'll start again at 9 a.m. Manila time. The first session will be on engaging the whole of the health system in the COVID response to meet surging demand. Then we'll have a short break, and then we'll have a session that looks at how we build and mobilise legal capacity, both for the COVID-19 response and for legal preparedness beyond COVID-19. And then we'll have a closing session where we'll wrap up, tie together some of the themes of the 2 days, look ahead, and then we'll have a keynote address in the closing from WHO Wipro. So thanks very much, everyone, for joining us for a fantastic first day. Looking forward to seeing you back tomorrow, as I said, at 9 a.m. Manila time. Thanks, everyone.